Good afternoon. I'm Dr. Liesl Bryant, and I'm a risk management consultant for the American Insurance Trust, known to most of you simply as the Trust. I am filling in today for Dr. Jana Martin and am delighted that you're able to join us virtually for the next webinar in our virtual webinar series. As a trust policyholder, most of you are familiar with the Trust's risk management consultation service, also called the Advocate 800 program. It's one of many benefits insureds receive through the Trust. I am one of the 6 advocates and am joined today by 2 other advocates, Drs. Daniel Taub and Eric Harris. I hope you enjoy and benefit from our roundtable today, and please join me in welcoming Drs. Taub and Harris.
Thank you, Liesl.
Yes, it's good to see you all.
Thank you.
So as usual, and welcome to all of you out there. As we typically do, we're going to start with just a couple questions that we already have, and then we will go from there into your questions, your live questions. So I see a couple of people are already posting, which is terrific. So please feel free to go ahead and add those in the Q&A box while we cover these initial questions. And Dan, I'll start with you. I know we've talked before about vaccination issues. And in fact, we've talked on a prior roundtable about this. And in particular with vaccines in terms of returning to in-person services, can we mandate them? Should we mandate them? Can we require proof? Those kinds of questions. I wonder, though, if you can give us sort of an update on whether or not there's been an increase in any legal issues about that practice, any legislation, lawsuits, board complaints, anything new that we should think about.
Sure. Good question, Liesl. But before responding to it, I want to give a bit of a caution here. You know, when a crisis is happening, and unfortunately for all of us right now, you know, we are still in this public health crisis. It does take some time for lawsuits and complaints to percolate, to surface, if they do at all. So as we continue to grapple with the COVID-19 and Delta variants and heaven forbid, epsilon variants and so forth, we're going to have to see how this evolves. And right now it is, my best guess, right, around some of these issues. And I'd be really interested in hearing both your and Eric input after I give my brief kind of response to the question. So to the best of my knowledge at this point, there have been few, if any, lawsuits and few, if any, licensing board complaints regarding having people demonstrate that they are vaccinated in order to come in person or continuing to see people remotely. Nonetheless, there have been many more legislative efforts across the nation, okay? And those have included legislators who have introduced bills to prohibit vaccine passports, as many of you have heard about, and an increasing number of states that have passed such laws, as well as states where there have been orders from the governor prohibiting such kinds of vaccine passports. An example is actually as early as early May, Florida's governor signed a statute into law that banned many businesses and also governmental agencies from requesting proof of vaccination, with a civil fine of up to $5,000 if that kind of request was made. Alabama, Texas have followed suit. There have been lawmakers in various parts of the country who have introduced similar, if not identical, legislation. States like Colorado, where it was introduced, it died before it made it out of committee. So it really varies in terms of the state. And the tension, Liesl, of course, is because in part of the politicized nature of COVID-19 and vaccination, and it has been posed as a pitched battle between public health concerns or safety, and on the other hand, individual rights. Okay, and those who are viewing individual rights as preeminent take these kind of rules as an imposition on those rights, particularly when it comes to government requiring it. Less so private businesses, but still being very concerned about government regulation. Okay, and then it's the right of an individual to address one's own health concerns and to decide when to disclose vaccination or not. Public health advocates, of course, view this as a community problem and one that requires laws, social policies, and decisions and mandates, much like other vaccination requirements, for example, for measles and so forth. And to make matters a bit more complex, usually in order for states to be able to mandate something and the feds to be able to mandate something, the FDA has to go through its typical approval process for a drug or a treatment. And right now, the vaccines are still on emergency status, despite all indications that it looks like they're going to approve. It could still take a while. It may be till September or December. We just don't know. An additional argument that's made by some of the opponents to requiring vaccination passports are that it's discriminatory in nature, that those people who either choose to or do not have access to or can't obtain their shots are excluded from services. So far, at least with respect to patient access, I'll talk about another area in a moment, I know of no cases that have risen to the level of any national attention, and certainly none that have gotten appellate interest yet. But there are some states that have gone ahead and even in the states with anti-passport rules like Florida, there are some interesting exceptions. And this is true for the governor orders, for example, in Arizona, where it says you can't ask for documentation except if you're in a healthcare setting. So even in the states like Florida that have said there's a $5,000 fine potentially, not if you're a healthcare provider. And for better or for worse, psychologists are definitely considered healthcare providers, at least in that state and in most states, okay? And though I really want to make a distinction here, what I'm talking about and what the question was about was, can we exclude clients on the basis of non-vaccination? And but there is some interesting parallel developments among employment or in employment law. The EEOC has put out guidance that says that employers can require employees to be vaccinated with reasonable exceptions or accommodations for bona fide medical or religious reasons. And in June, a district court in Texas, a federal district court in Texas, in the Bridges case, threw out a lawsuit by a number of healthcare providers who are working for a hospital who are being required to be vaccinated. Okay, so while it's uncertain now, and my pretty cloudy crystal ball is not going to be perfect, it's probably not too risky to have a policy of in-person for vaccination patients only under two conditions. One, as long as we're offering comparable services in telehealth, right? And much of the research suggests that the outcomes are similar. There's not a huge amount, but emerging research is showing that. And two, that we have reasonable exceptions for people who, because of lack of access to the technology, lack of access to vaccines, bona fide medical or religious reasons, wouldn't be able to get or would really be at risk to obtain a vaccine. If you want to avoid the issue completely, and this is a purely kind of bad law driven, as Eric, you so aptly put it, if we're worried about the worst case scenario being sued for discrimination, the way you avoid it is either wait and continue to do telehealth until there's herd immunity, when and if that occurs, or say you're going to see everybody in person, but make sure that everybody is masked and using all of the pre-vaccine precautions, in which case many clinicians object to that because how do we do good work when we can't see facial expressions? Rather do it remotely. But still, that would be a way of practicing and that would avoid any allegations of discrimination. But to make it clear, my own sense, and I'm interested in yours, Eric, and yours, Liesl, is that I don't think the risks are high here if one provides a reasonable alternative and reasonable exceptions.
Thanks, Dan. Eric, do you want to jump in there?
Well, I agree completely. But mostly, I think what we've now learned is the pandemic isn't over.
Mm-hmm.
And that means that people my age, or even many younger than me, are still really at risk. And those that we love are really at risk. And we are healthcare providers, which means in most states, we have to take precautions, even if we are vaccinated and our clients are vaccinated. We still have to wear masks in the office and stuff. So with all of that, I think that one should look carefully at one's own health needs and the health needs of one's client. You are offering them an alternative in providing, since we are basically saying that there isn't any difference between telepsychology and in-person psychology, that's been the position that we're taking, then to say, you can have therapy, I'm not going to provide you therapy, but if you want to have therapy with me in my office, you have to be vaccinated. Or you need to have a very good reason why that's not the case. And, there may be a case or two where that won't work, but I'm less worried than Dan that there's any real risk.
Mm-hmm. Mm-hmm.
Because healthcare, everybody's afraid to mess with healthcare.
Right.
Right. I agree. Thank you both for your comments. So Eric, we'll move to you with the second question here. And it's actually a short scenario and then followed by the question. So the scenario is, during the pandemic, several of my clients relocated to different states. For those who were appropriate, I continued to see them because those states allowed practitioners with an equivalent license to practice without a license during the pandemic. So there was some kind of COVID waiver or loosening of restriction there. At some point in the future, or even currently, depending on the state, states will declare or have declared the state of emergency over. How should I plan with my clients for continuity of care in this situation?
Thanks, Liesl. Well, as Yogi Berra, that eminent American sage, said, it's tough to predict things, particularly the future.
Mm-hmm.
While I was preparing for this, I was preparing with the notion that we were in that stage that we were in about 6 weeks ago, where the pandemic was over. As of the fall, we would all be back to normal, and we wouldn't have to worry any of this, and we'd be back to the rules that existed prior to the pandemic being started. That now doesn't seem to be the case. So what I would have said in that situation earlier is, for most of your clients who have relocated to other jurisdictions, you're going to have to figure out a way to terminate with them appropriately. And Dan is going to talk, I believe, in the next question about how to do that. Mm-hmm. But I also want to say that we have to look, in order to figure out entirely what the rules are, we have to really look back to what the rules were before the pandemic occurred, although I know that for most of us, that seems like the ancient past in some ways. At least it does to me. Before the pandemic, when telepsychology started, regulators had to figure out how they were going to regulate it, which meant that since telepsychology takes place in cyberspace, which is not yet a regulable entity, they had to find an earthly site for where the transaction takes place. And rightly or wrongly, I think probably rightly, although there were pros and cons to each approach, they decided that in order for states to be able to best protect their consumers, they would say that the transaction between a therapist and a client that crosses state lines takes place where the consumer is, also known as the forum state. And that means that according to state laws that were present, most states, well, there are two types of state laws. For the most part, practicing across state lines, a state would say is practicing without a license, which is a misdemeanor criminal offense. Almost all states have some temporary practice, although the nature of the temporary practice rules is all over the place. So in California, you can get 30 calendar days in any order. For most of us, that means that if we've had somebody that's relocated to California, we have plenty of time to figure out how to terminate them appropriately and get them to somebody new. What I've traditionally said is it makes sense to, if you can, continue to work with a client temporarily until they get settled in the new jurisdiction, because your existing relationship will help them with that process. And for most states, I think that's pretty not very risky. However, the issue, and the trust has always been sort of out front about this, is that there have been a number of court cases that said the state rules saying you can't practice in another state without a license in that state have exceptions. Some would say the exceptions are large enough to drive a very large truck through. But that's not what our advice is going to be. The exception essentially is that the cases said that essentially a physician needs to be able to do more for someone who is moving to a different jurisdiction than give them enough aspirin to get there. And that as long as the provider was providing a continuation of services which was appropriate and necessary for the client and was not really doing anything else to try to do business in that particular jurisdiction, that state could not assert jurisdiction over them. So they would be essentially safe. And this was kind of controversial at the time that when we said this, but I have to say that the person who was the CEO and Director of Professional Affairs of ASPPB took our workshops, heard our arguments, and said that we were essentially right. Okay. Without getting too much into the weeds, I think that where you have been working with a client for some time, and there is a good reason for you to continue to work for them. And the way I define that, and I think the other states would define that, is where referring them to an in-person therapist would somehow not be what they need, would be considerably less valuable than you're continuing to provide services to them. Which means that in order to do this, you need to do a case-by-case analysis of the situation to decide what you're going to do. Now, having said this, when we used to give advice about this, we had somebody that had one client or maybe even two clients. It was before the pandemic. So it was easy to say, okay, these are exceptions you can make for a certain number of appropriate cases. I had somebody call me the other day that said, I have 10 clients that have relocated during the pandemic. Can I apply this this kind of analysis to these 10 in order to be able to continue to do it? And I can't say that there's tremendous risk in doing it that way. It seems to me that's really pushing the limits. And I would say you need to be selective about the cases that you're going to do if you choose to do this. But so far, although Lisa, when we were rehearsing, told me that she knows of a couple of cases where they're considering criminal complaints. We only knew one criminal case where somebody was actually convicted. Mm-hmm. And that was in California, of course. And that's a long story, which we won't go into. A very interesting kind of case. But the point of it is, what this guy did was very egregious. And as I understand it from Lisa, what she's talking about are also cases that are forensic in nature, and there was also egregious conduct. We are not encouraging you to engage in egregious conduct. I want to make that absolutely clear. That is not good risk management. So, what are the things that you look at? What are the kinds of cases where you might consider continuing to work with someone? Well, what about the people who are near state lines and who have had clients that used to come and see them, say, in New York City, who live in New Jersey, but now will at some point in the future be able to come and see them in person, but really can't yet. But if New Jersey then changes its temporary practice rules, which I believe they've already declared the emergency over, yes, technically you would be violating the law by doing that. Now, we're not saying that you should see people exclusively that way, but if a client occasionally can't make it, or if there really are health concerns that make it impossible for the client to, in the current moment, travel across state lines, the possibility of anything bad happening to you, as long as you, in your notes, have a very good justification for why you're doing what you're doing. And then the question becomes, how long is this going to go on before you really need to consider it being too long? One of the things we would say is, before you think of doing this, although we would be in danger of saying that we're trying to solicit more work, is it would be good to consult with a trust, because you want, first of all, to look at what the temporary practice rules are. You want to look at the case situation, consulting with colleagues and getting advice about whether to go forward or not, if you follow it, is really good risk management. And of course, the next thing you need to do is carefully document what your reasoning process is. And also have good informed consent for the client so they understand that there may be at some point an interruption. Because what's most likely is, if there's a problem, you're not going to get a criminal complaint filed against you, because there's all sorts of things that make that very difficult for a state to do. But you may well get a cease and desist letter. if there's a complaint. It won't be, if it's from the client, you won't have a problem knowing you should stop. If a client complains about you, that's a good signal that you obviously haven't made a stupid decision and you should stop immediately. But it may be a relative, there are a lot of complaints that come from people who aren't the clients. And that can trigger it. The other situations is where there's a long established clinical relationship. If you've been seeing someone for 4 years and you're a psychodiagnostic person and you're really getting to the end of treatment, but not there yet, obviously that would be a case in which you could make a rationale, an argument that you can continue. If you have 15 clients in different states, that's probably not going to work for you. You're going to have to pick and choose because you are skirting on the boundary of violating the law. Even though we have this rationalization, if you flaunt it, it's likely to be problematic. Another particular kind of case is where you have working with a divorced couple and a kid, and one of the parents is out of state.
Mhm.
It's impossible to do therapy with a divorced couple and a kid if one of the parents can't participate in the treatment. Because that parent is going to feel, with probably good reason, that they're not getting a fair hearing. And since divorces are often high conflict divorces are one of the most serious kinds of complaints that we get, that's one of the situations. A return to college with coming home for vacations, that's more iffy. Depends to me on that, depends on the facts and circumstances as well. If you've been working for someone for 3 years of high school and you need to continue and they're about to go to college and one of their problems is an anxiety issue, and the issues of going to college now are fraught with stress from COVID and a number of things, it might be justifiable to say, I don't think having two therapists, they need therapy, and the only alternative to my seeing them across state lines is for them to get a new therapist where they are, and then they'll have two therapists because they're going to come back. And, the vacations for schools now are almost as long as the students are in session. And finally, where there's a temporary dislocation, where someone has moved to Florida because of the pandemic, was planning to come back, and now, because of the Delta variant and what's going to come after it, because I don't think I think we are no means, I'm sorry to say, we're no means through this. I think that, and I think it's going to be hard for people to understand that, because I think there was a sense that people were going to be finished with this. And the other thing I will say is, if you're transitioning and you take a few sessions while the person is in the other jurisdiction, even though that technically violates the rule, I don't think that's going to, for a long time after the pandemic is over, the boards are going to be so busy with things that are serious. For example, having to deal with SIPAC and people that are licensed that aren't SIPAC. And how are they going to regulate SIPAC versus regulate people that are licensed in the state and aren't SIPAC? And so as long as you really have a good case to be made for the work that you're doing, you're probably going to be okay. And I would suggest you call, but we have consistently been able to work with people and recommend in many cases that they continue.
Mm-hmm. Yeah, thank you, Eric, for that. Dan, do you want to add anything there?
No, I think, Eric, you hit the nail on the head.
Yeah, no, I agree. I will just sort of, it's not really an addition, more a highlight of, I think it's potentially less riskier when we're doing that on the short-term basis. Like you said, if it's going to go on for a year or two or three, that's tricky.
No, if we had more time, we
yeah,
could spend a lot of time going over sample cases.
Exactly.
Because it is always the facts and circumstances. So the longer you go on, that's more of a risk level.
Right.
But the more important your relationship with the client is, that's a different balancing part.
Exactly.
So I would agree with you that you need to be careful and get good advice. But what you want to do is be able to give the person the service that they need, if it's possible to do that without going over without doing it too often.
Right, without flaunting the law, as you said. No, and I love how you say that, because it really highlights that, again, it is case dependent. I mean, every case is really different. And we do want to be a little choosy about which cases we do this. Like you say, not all of our clients do we want to do this with.
Oh, no, that's the other thing I didn't say, which is that you also, one of the things you must make sure of is the client's appropriate for it.
Yeah.
And there are certain clients that are high-risk clients, which they might need your services, but that would add to the risk level and make it unacceptable. Again, it's an analysis on a case-by-case basis.
Mm-hmm.
For example, I would not do DBT across state lines.
Right.
Yeah, and forensic cases, as you highlighted,
Forensic,
probably not a good idea.
That's a whole different.
Yeah,
Right.
unless you're licensed in the other state, right? That's the key. But if you're,
Oh, yes, unless you're temporary, there's a number of issues about that because many states allow somebody to come in and testify,
right,
but not do anything else,
not
and
the case. Yeah.
it gets to be a borderline thing.
Yeah, exactly. So, okay, I am aware that we are already at the half-hour mark. We have two more of these questions. I'm going to go ahead and ask them, but for these two, Dan and Eric, I'm going to ask you to answer as quickly as you can.
Okay.
So and then we'll take live, and then if people have follow-up questions, we'll take those too. But I do want to try to get to the live as well. So, Dan, I'll come back to you on this one. A little bit of a situation, and then a few questions to follow. So here's a scenario. I work with teens and young adults. I currently have a few fairly high-risk patients in their late teens who are planning to move out of state to college in the fall. None of those other states and/or my own state are SIPAC states, and I'm not comfortable with continuing care over long distances, especially with these potentially tricky or higher risk situations. Can I end treatment? And if so, how can I do so in an ethically sound manner?
So, this actually dovetails well with Eric, what you've been talking about, because this is the other half, or perhaps, less than that, or maybe more, of when you are going to end. How do you do it, and how do you do it appropriately? And first, just as a note, Liesl, there's no requirement that one continues. If you're licensed only in one state and a person goes to another state and that state does not permit you to practice there, or has a very limited temporary practice rule, there isn't a requirement that you get licensed there. Okay. There may be an ethical argument for why you might want to continue. And this is one of those interesting kind of gray areas, because it's not really kind of a voluntary, termination where both the client or patient and the clinician have decided therapy's over. The clinician is saying, I need to stop, but neither is it really at the clinician's initiation per se, because the person is moving out of the jurisdiction. So because of that gray area, there are a few steps to take that can significantly reduce risks, and also importantly, really support the continuity of care. And it very much fits, Eric, with what you were talking about in terms of the, suitable, non-suitable clients, and also shorter term, Liesl, that you and Eric were just talking about. The first step is to have a well-documented conversation with the client. And if they're a young adult and they give permission, or they're not yet 18, with the parents as well, assuming that 18 is the age of consent, and inform them that because you're not licensed, you won't be able to continue to provide care in the other jurisdiction. The second of these two steps, so you're giving the information, or what's called notice. The second is give recommendations. What kind of services do you think are appropriate for this person? And that could mean just temporary services to assist in the transition to living on college campus. It could be something much more extensive. And then the third is to make referrals. And those might be to a college, counseling and psychological services center, or it might be to a professional or set of professionals in the community.
Oh my.
Oh no. Dan, we can no longer hear you. I don't know. I think he can't hear us either. So Eric, maybe he'll catch on in a minute. I don't know if he can see us. Okay, Eric, I might let you take over. Oh, wait. Okay, he's putting it on.
Can you hear us now?
Can you hear us? Oh, we can't hear us.
All right, well, let me just.
Yeah, if you want to step in, Eric.
Mostly he's covered it. I think the answer is, if you want to stop, you can, because what you're saying is I can't legally do it. Even though we've just told you that legally you might be able to, we can't. Dan's going to call in and we'll see if we can get him on. But I agree with that. I think that he's mostly said what needs to be said, which is that you should do it on a case-by-case basis. And that if you take some time to do it and give there be a transition period where the person is in the new jurisdiction, if that's appropriate, there's almost no risk whatsoever of doing it.
Right. Yeah, no, I agree.
We're dealing with kids of this age. I wouldn't work with them across state lines unless normally when I'm treating an adolescent or a college age student, particularly my own, many college age students are what I call unemancipated adults. You want to basically, if they're going to out of state, you need to have access to their parents. You might not want to have access to their parents when you're working with them in state, because that may be a problem for the therapy. But when they're going out of state and something bad could happen, not being in contact with the parents, I think, is a high risk factor. Now, again, it's a case-by-case analysis.
Yeah, no, I agree. Case by case, and of course, as always, documenting whatever your rationale is, regardless of what way you choose.
Yes,
right?
absolutely, of course.
Yeah,
and consulting as well.
Yeah, and we do, as you know, Eric and Dan, we get a lot of calls on this because some of these are tricky. These are really tricky. How do you know which case to follow and which case not? So, okay, Eric, I'm going to go ahead and give this last question to you, and then we'll jump into the live questions. Again, a brief scenario. I've been approached by the parents of a 15-year-old girl. The parents are divorcing and their relationship is quite contentious. I want to make sure I can maintain my client's privacy. In my state, parents have a right of access to the records of the minor child. What can I do in this situation?
So let me say that the last sentence is the crucial one in answering this question, because there are a number of states where parents, when the therapist believes that it would be damaging to the child, can refuse to turn over the records. In fact, in Massachusetts and Maryland, for example, it's required that a neutral legal person, the guardian ad litem in Massachusetts, and some kind of child lawyer in Maryland. So this wouldn't apply to those states, except that this is one of those one size fits all, which is you need to have a contract with the parents that the child knows about, where everybody sort of knows what the rules are, and where you basically say, as by the way, we have one at trustinsurance.com, and I think it's very good. And I'm not going to go into the language so much, except to say that it makes clear to the parents why you're asking them to agree that they won't seek the child's records, and if there's any court cases, they won't subpoena you to testify. And what you say to them is, when somebody is a child, particularly an adolescent, having a zone of privacy is almost crucial for therapy to take place. If you tell me that I have to tell you everything that your child says to me, your child is unlikely to use the therapy as much as they could. And so you might in some ways be wasting your money, because the more difficulty you're having with your child, the more resistant they're going to be to giving me information that then you will get. So we have a contract that language is made very clear to the parents, and we recommend that you get them to sign it. Now, in a state like you're in, where the parents have access to the record, that may not be a binding sufficient contract. However, you will be able to maintain your relationship with the child and assert that the contract is binding up until the point where a court actually orders you to give information over. And in many situations, your parent, when a parent, because when you're in a contested divorce, particularly a divorce to the death, which we get quite frequently, people forget their child's best interest. They're busy fighting the battle with each other. But if you have this contract and you remind both parents of it, if they talk to their lawyers are going to be reluctant to violate it, because the court's job is to determine what is going to be in the child's best interest and who cares about the child enough for that to be part of the decision-making. And if you're willing to blow what you agreed to, where you understood that your child's confidentiality was really important to the therapy, that's not a good look if you're in this. So we've found that when people have these contracts, they don't always work, but they work well enough. Now, the one thing that is important about these contracts is, if possible, you need to have a conversation with the client and the parents about what constitutes dangerous conduct which you would then breach confidentiality. Because while it is true that children need a zone of privacy, you also can't responsibly work with minors if they're engaging in dangerous behavior that you then can't tell their parents about. And sometimes some therapists decide that the parents will just say, you decide what's dangerous and what's not. We think it's a good idea to have a conversation about it, because that may be the first time the family has ever had a conversation like it. With the kid and the two parents saying, well, we think it's dangerous. Well, I don't think it's so dangerous, well, you know, and then all of that. So it actually becomes part of the therapeutic process.
Right.
I can go further, but you want to stop. So.
Yeah, I do, just for time's sake. But yeah, no, you got in a lot of details. There's a lot of information. I will say someone is asking for the link. I can't type the link in right now, but it's on our website, trustinsurance.com. Go to the resource tab at the top and then into the document library, and you'll find all of the informed consent documents under there.
It's not hard to navigate.
Yeah, very easy to find.
So Liesl, Eric, I am back again.
Terrific, terrific.
Do you want me to finish up?
No,
actually, yeah, we already did. Sorry, Eric, we already did finish for you.
Okay, great.
And,
awesome. Thank you. Oh, no,
yeah.
that's fine.
Okay.
Thank you.
For the sake of time, I'm going to dive right into the online questions or the live questions that are coming in, because we have a lot of them, as we normally do. Okay, so one question: if one of your therapists, so I assume this is like a group practice, maybe this is the owner asking it, but if one of your therapists refuses to get the vaccine, do you have a quote legal obligation to tell clients before they see them that in essence the therapist is unvaccinated? Dan, do you want to start on that?
Sure. Actually, I think it really will depend on the jurisdiction about a legal requirement, but I think there's a very clear ethical requirement. And the ethical requirement would be informed consent. And folks need to know what they're getting into, particularly in the context of increased risks and Delta and so forth. So if there's then an ethical risk to it, and a significant one, it's not just a convenience issue. I do think that the client's rights to know here are going to outweigh the clinician's right to be able to not tell people about their status, particularly if they get sick. And I suspect, and Eric, I'd be interested in your perspective, that a jury is going to be likely to agree with that when somebody gets seriously injured or dies.
Again, I think the issue is the person can keep providing services online. So making them choose between vaccinations and seeing clients in person, or non-vaccination and not seeing clients in person, does not seem to me to be an unreasonable choice to put them by. And from a risk management standpoint, I think it's absolutely crucial that you do it. Not to mention, what does it mean that you have somebody in your practice that is going to assert that they can't be made to get a vaccine when it involves the health of the whole group of you that they're working in?
Mm-hmm. Mm-hmm.
Now, I think this may be, and I don't want to get too much into the political weeds, it may also depend somewhat on the state that you're in. I don't know that Florida is, I mean, Massachusetts or California, I have pretty clear feelings about what the rule would be. In some of the states that have been so politically antagonistic to vaccines, it could be more risky, but they all have an exception for healthcare. So I think in the end, I would say to them, you have to choose. You can keep working here, but you have to do remote until you get vaccinated, at which point you can start to see people in person.
Yeah, I agree with both of you. And I think, because we are healthcare settings, I don't think there's any way to get around that ethical piece that you would have to tell, clients have to know whether we as the clinician are vaccinated or not.
The other thing that I think I just want to add, again, I think we've sort of mentioned it, is because we're a healthcare setting, you have to also be aware that the pandemic isn't over for you. The healthcare requirements, public health requirements in almost every state is that you mask and continue to take precautions. And therapists have asked me, well, I can be more than 6 feet apart in my office. Can I take the masks off then? And the answer is no.
Right.
You may think it's ridiculous, which I kind of do, but that's the rule.
Right.
Right. Okay, so a slightly different question. Thanks to both of you for that. Another question, what are your thoughts on clients' requests for medical support letters for accommodation? Specifically, clients wanting to stay remote while work is returning to in-person in the office. And at present, all of the worry is mostly anticipatory. So thoughts on that? Eric, do you want to take that first? And then
I think that it's the same thing whether we weren't in this situation. Clients can ask you to give data to other folks, but they shouldn't be able to manipulate you, no matter how much you care about them, into making legal conclusions that you're not competent to make.
Right.
So what you can say is, the client has said X, Y, Z. I've observed this. I've been treating them for serious anxiety. It's clear to me that if they're forced to do this, they'll be much more anxious. And I'm worried about the psychological ramifications of that. But that's really all I can say.
Mm-hmm. Mm-hmm. Dan, any additions there?
Yeah, I would say that there are two other dimensions that I would consider, and these are all supporting what Eric has said, Liesl, and that is, first, there's the issue of whether one's competent to render that kind of opinion. You know, if you're being asked for coming to a conclusion that's more of a disability assessment or a forensic assessment, and you're not trained to do that, then that also raises that ethical concern. And then the other piece is just, what are the data you're relying on? Because if the data are simply the client, and much less so with a client you've known for a long time, and there's been, you know, a warp and woof of the anxiety that they've experienced, versus the person who comes in for 2 sessions and says, write me a letter, you know. And so my sense is that the data you've got about the person, its comprehensiveness, and the switch of roles is another, you know, the competency issue are two other issues in addition to what Eric is raising.
I would just say one more thing to add. If they're coming to you because they want the letter, you shouldn't send it.
Exactly.
Yeah, and I think it's important in these cases to really look at what is it they want the letter to say. I mean, this fits with what you've both said, Dan and Eric, but what is it they actually are requiring you to say? Because you may or may not be able to say that. You may need to know what the work issues are, like what are they going to be required to do, and make some decision as to whether or not their mental health issue will impair that ability to perform. Most clinicians aren't doing an assessment at that level. So if they're going to require you to state that, I think you've got to really state your clear limits and go back to what you were saying, Eric, which is I can say what the patient's told me, I can say what I've observed in session, but not going much beyond that. Okay, this I think will be short. Is Medicare still allowing phone therapy? Dan?
Yes. They are until the end of the public health emergency. And there is a push, and actually they're talking about extending through to 2023 rather than 2022, but with the interesting proviso that once the public health emergency is over, that they're going to be complying with a relatively newly passed law requiring at least one in-person session within the past 6 months. And so right now, and you know, for at least the next few months, we've got the Medicare exception, but you have to keep your ear to the ground because things may change, and we have to see what happens with Delta and Epsilon and so forth, and the public health emergency.
Mm-hmm. Perfect. Thank you. Next question. Can you speak to the risks and downsides versus advantages of doing a wide range of activities under a single private practice business entity? So for example, workshops, coaching, lectures, presentations, as opposed to creating a second business, LLC or otherwise, to be designated for non-psychology practices. Eric, do you want to start on that one?
Yeah, if the activities are all the practice of psychology, and if you look at the scope of practice in most state psychology laws, anything that uses your psychological knowledge to in some way affect human behavior is considered the practice of psychology. There is no need to divvy up into separate businesses, which just cause certain complexity. Particularly then you might have to get separate EIN numbers, and then you'll have trouble with the IRS. It's just, by and large, it's not worth it. Now, if you have a big business that's generating a lot of money that isn't strictly psychology, like coaching. Some people think it makes sense to have a separate business, but I'm not suggesting is that by having a separate business, somehow that makes what you're doing in the separate business less regulable. You're still going to have to follow the rules about the practice of psychology, even if you're coaching or doing workshops. Now, teaching is not covered by most licensing laws, so that doesn't require anything. But for most of the people that have called me with that question, I feel very comfortable saying there's no need to do it.
Mm-hmm. Great, thank you. Dan, any comments?
I agree with Eric, and I think the times that might be different would be if you're going to really go wholly into, for example, hosting continuing education, right? And you want to create that business. That may be worth having a separate business entity, but other than really a very distinct non-psychological, set of activities, it gets complicated, and it makes more sense to keep it simple. Also, just to underscore something you said, Eric, that when you read most of the statutes across the United States that are psych licensing statutes are taken from the model language from APA. And the APA model language is so broad, you could sneeze when you're wearing your PhD hat or your PsyD hat and you're being a psychologist. So I tend to think, that it doesn't make sense unless you can truly define a separate non-psychological business. And that sometimes may require talking to an attorney and so forth. The juice may not be worth the squeeze,
Mm-hmm. Yeah.
One exception that I think, which is if you were a psychologist who specialized in people's habits about money, and you were advising people about investments based on some kind of psychological analysis, that gets close enough to being a separate, out of the range of psychology business, that I would want to consult with a lawyer before I'd even do that.
Mm-hmm. Yeah, and just to underscore it, and we say this a lot, but right, if this is one thing where if you have real questions, it's important, I think, to call in and consult so we can talk with you about what are the specifics that you're looking at, because I think we've given some general advice, but we can imagine some different scenarios that we might change that. So okay, we've sort of answered this, but I think it bears repeating because we get lots of questions about this. It says, I thought the CDC required masks in healthcare settings, whether or not the individuals are vaccinated. Do we fall in that category if in a private office setting? Dan, why don't you jump in there?
Yes.
Right. And Eric, you were nodding your head. Yes,
absolutely.
Yes. The short answer there is just yes, we do fall in that. So yes, masks are required. Okay.
Nadia, by the way, I just want to say, that's something which you not doing could really involve you in a licensing board complaint. Mm-hmm. Saying, I don't like wearing masks, I don't need to anymore, we're both vaccinated, we'll separate, take your mask off. I wouldn't do that, even though it makes a certain amount of sense to me, because I think that really gives the power to somebody to complain successfully against you with the licensing board.
Mm-hmm. Yeah, I agree. The risk there is much more about a licensing complaint than any kind of suit or something like that. It's really more about a board complaint, right? Okay, if we want to go by, quote, first do no harm, and breakthrough cases are happening in greater frequency now, shouldn't we all not practice in person at all? And I can't remember which one of you went last, but Eric, why don't you just jump in there?
Okay, well, I think that's a personal choice. Mm-hmm. I think that you could make the argument, as you have just made the argument, whoever asked that question, but there are some people that think if both parties are vaccinated, that reduces the risk to a level that is acceptable. And for those people that feel like there's a good reason for them to want to practice in person because they personally feel more comfortable and think that their work is better, I think that they should go with that. But I also want to say that this, you have to stay tuned.
Right. It might change in coming weeks or months.
Exactly.
Yeah.
Mm-hmm.
Okay, so a couple more. What if the provider considers her health at risk? I'm not comfortable seeing unvaccinated people, or at this point, anyone in person, even if they don't have a computer or telephone. So I think the question here is a clinician required to go in person if they themselves are worried about their own health? Right. We see both of them shaking their heads no. The answer to that is
Yeah, we're both shaking our heads.
yeah.
So just briefly, Liesl, I had a wonderful supervisor, worked around some folks who were pretty violent at times, and I had a wonderful supervisor say about the safety of the clinician that clinicians don't do very well when they're dead. So it's better for us to stay alive and stay healthy, and we have to be mindful of that. And while it was a joke, what that person was talking about, if you expand on it and you really think about this context, is that the clinician's health and vulnerability is part of the calculus, and it is an important part, because we're not going to be able to continue to provide care if we are vulnerable, really are thinking I shouldn't be doing this, and you go in anyway, even with masking and so forth, because we're all aware of that possibility. So I think it's while a kind of a tongue-in-cheek comment that Norm made years and years ago, it still holds true today.
If, for example, I was immunocompromised, I wouldn't work in person. Just too risky.
Right. Okay, so this one, not so much a question, but I think it does bear clarifying. So someone is pointing out here that under PsyPact, it's not about where the clinician is, it's not about where the client is located, that it's about services are deemed to take place at the physical location of the psychologist. And we do want to just clarify that is true. When Eric was talking earlier, he was talking about outside of PsyPact, just sort of more generally. PsyPact is very specific and has a unique home state rule and some issues like that we're probably not going to get a lot into tonight, but that is an accurate clarification. So we do want to make that, and thank you for writing that in. Anything short you guys want to add to that before we take another question?
Yeah, just briefly, that is clear, and the home state rule is accurate, but PsyPact has also posted a legal opinion that suggests that you also have to abide by the laws of the forum state. So it's very complicated, and we don't know yet how it's going to play out.
And how one finds out about what the laws are of the forum states of 25 different states, as yet they have not produced a database that's going to be able to do that. So there's a lot of things about PsyPact that, to me, are not sufficiently resolved to be able to give good advice.
Mm-hmm. Okay. So thank you guys. On a slightly different note, for neuropsychology, the offer of telehealth is not the equivalent as in person, and it likely does not meet the standard required for most courts. So how can you address the issues of providing a quote equivalent alternative via telehealth, given that, given this, can I still request proof of vaccination and negative testing? Dan, you want to take that to start?
Sure. So this is a good example of exceptions to the rule, right? Where we've been saying you could keep doing telehealth. There are some services, and neuropsychology, particularly forensic neuropsychology, is one set. And so in this context, what I would recommend, and the person who's asking the question may well know this, there are some great resources on the IOPC.online site. That's the Interorganizational Practice Committee.online site, where they give a whole series of suggestions about how to do hybrid neuropsychological evaluations. I think the key here is you have to be very careful about both choosing tests that have some, at least initial, reliability and validity statistics on even hybrid administration, and you have to be very forthcoming about the limitations on your data. And in addition, if you are going to be doing neuropsych for a forensic process and you're using some telepsych and some in-person or modified in-person, I would want you to be having a colleague who's comfortable doing this with you cross-examine you on the validity and reliability of the test and the data, so that you know whether you feel comfortable sitting in court and answering the question about whether you can come to the conclusions you have come to.
That's a great suggestion. I'm going to actually take one more quick question because I'm noticing we're getting really close to the end. And this is one that it's not exactly the same, but we get a lot of questions of this variety. So I think it's good to just give a general answer. But what about patients traveling in their RVs? Or we've also gotten the question, what about patients traveling on boats?
Truckers.
Or truck drivers, or lots of people like that. So what, Eric, can you give some
Sure.
quick, but
I think that it's,
advice?
again, we've had this question with people. The question becomes, is it not possible for them to get therapy any other way than for you to do it with them? Truck drivers are pretty easy. They can't get therapy unless you're willing to work with them across state lines. It just can't happen. So what you would be saying is, if we can't do that, there isn't any way for these people to get services at all. So I don't think that's an issue. RVs, that's voluntary, and I think it's a little bit more complicated, and it depends on how long they're going to be away. And again, it's the same kind of thing we would say before. Call us and let's go over the case specifically, because a lot of what we would advise in that situation is dependent on the facts and circumstances of the case.
Yes.
Sometimes it'll be okay, sometimes it won't.
And one of those circumstances would include assessment of the clinical suitability of that particular client.
Absolutely, absolutely, and their need.
Right, exactly. Yeah. Dan, any last minute comment before we turn to CEs?
No, I think, Eric, you said it just fine.